Welcome to Law and Crime's Daily Debrief, everybody. Yet another juror who convicted Harvey Weinstein of rape is speaking out about how jurors arrived at their decisions. In an interview with CBS News, the juror said defense tactics to paint a pattern of consent meant very little in the end because, after all, as we have said on this broadcast before, two people can have consensual sexual relations 10,000 times, and one act of non-consensual sex is a crime. The juror described the deliberations as conscientious and explained why the jury believed Weinstein was guilty of third-degree rape, not first-degree rape, as to accuser Jessica Mann.
It wasn't rape in the first degree. There was no physical compulsion with the threat of bodily harm or death, but there was no consent given despite a lack of physical resistance, and a reasonable person should have known that there was no consent given in that instance. It's an alleged incident, not kind of this whole canvas of relationship. It's, you know, husbands can rape their wives, and it's a complicated issue for sure, but it was our contention that it's one incident.
The juror also explained some of the rationale for the jury's failure to convict on the testimony of Annabella Sciorra. Her claim was too old to prosecute independently, so it was added to the claims of the other two complaining witnesses in a failed state attempt to secure a longer sentence for Weinstein.
That's a very high burden that the prosecution took upon itself in bringing these charges. It's 27 years ago, and in this country, you know, you and I and even Harvey Weinstein are innocent until proven beyond a reasonable doubt of the opposite.
And today on the Law and Crime Network, a former producer at NBC who worked with Ronan Farrow talked about what he called NBC's decision to kill stories which could have exposed Weinstein back in 2017.
We've learned that very early on, Weinstein was aware of the fact that we were trying to report this. And we know soon after the Rose McGowan interview in February of 2017, he was aware of us, and he had employed Black Cube to look into Rose. But when we met with Rose and did the interview, I think he was aware of us. And so daily emails would go from Black Cube associates to Harvey saying, this is what McHugh and Farrow are working on, etc. And NBC executives confirmed to his lawyer in the middle of the summer that we were no longer working on a story on Harvey Weinstein. These women, to a T, none of them wanted to be in this situation, and they've gone through incredible trauma in the years, in the decades following. And so for him to say these were specious claims or whatever, it speaks to a guy who's been able to operate with impunity for decades and hasn't really had to be accountable to anything. And I think we're just seeing the levels of concentric circles that protected this guy for decades. And I think that's potentially the next focus.
A recent article in The Telegraph has resulted in backlash over a headline which many people perceive as crediting attorney Lisa Bloom and her mother Gloria Allred for taking down Weinstein. Allred represents several Weinstein accusers, that's true, but Bloom used to work for Weinstein himself. The headline reads, "Meet the mother-daughter duo fighting Hollywood's most powerful sex abusers in court." The subheading says, Gloria Allred, lawyer for two women who testified against Weinstein, and daughter Lisa Bloom on their next quest for justice. Here's how the former NBC producer who worked the Weinstein story reacted.
I mean, it was clear as day what, at a certain point, what her role is in, you know, it's documented. She admitted, you know, to Ronan directly. She said, you know, when we were trying to figure out her allegiance about who was his people, and Ronan confronted her and she said, "Ronan, I am his people." She made a calculated decision, and the New York Times reporters have documented this too. It's like she had long been working on behalf of victims, and then went to the dark side and represented Harvey Weinstein. And, you know, that's just, in my opinion, that's unforgivable with what she does. And I think she's trying to rewrite history.
Four attorneys joined us tonight here on The Debrief as guests. Brian Buckmeyer is a New York public defender. Andrew Cherkosky is a California trial attorney. Andrew, let's start with you here. Reaction to the comments of the juror who spoke to CBS have been positive. Do you think that juror followed the law in a way which is immune from a successful appeal by Weinstein? Andrew, I don't know if you can hear me here.
I'm having issue with audio.
Okay, so let's skip and head to Brian Buckmeyer here. Brian, I'll ask you that question. Your take on the interview from the juror there?
Yeah, I think it was actually, it gave me a lot of faith in jurors. They took the job seriously and they analyzed the testimony, and I think they parsed through a lot of the arguments that the defense was hoping that they can hang their hat on and zero righted on the issue and found, I think, it correctly that he was guilty of that act, so long as they found the witnesses credible, which they obviously did.
Yeah, I mean, so ultimately the credibility quotient rests on the jury to decide here. It's not for you, not for me, not for anybody else to ultimately make that conclusion. In appeals courts, as you know, Brian, usually, or almost always, I should say, 99.999% of the time, credit jurors with decisions like that.
Exactly. They're reviewing the testimony of the witnesses by what's in the record. They're not going to go on a fact-finding mission themselves. And they kind of leave it up to the jury. They said, hey, you're supposed to be judged by a jury of your peers. And if your peers believe this witness, this victim, and we should start calling them victims now because he is convicted, then we're not going to second-guess them.
Andrew, your thoughts on the juror's interview today?
I thought it was spot on with an analysis of the law and how they came to their decision. I thought he was a very respectful indication of how they viewed Harvey Weinstein's presumption of innocence, as well as their understanding of the law with regard to whether threat of grievous bodily harm or death was utilized versus the third-degree finding that they came to. Also with regard to the timing that goes by. I just thought it was a very thoughtful and accurate reflection of what we hope jurors have to struggle with in reaching the tough decisions they do.
Andrew, I agree with you. I think this juror was a model juror in that respect. The interview was very insightful. Let's turn in studio here. Bruce Barquette, Aida Leisenring joining me. So, Aida, a lot of people were surprised at the lack of the jury's credit to the testimony of Annabella Sciorra, perhaps even the prosecution, because the prosecution called her as the first complaining witness. But the bottom line here, that juror said it was too old, and again, it's the jury's call to give a factual credit or not to a witness's testimony.
Yes, and I think that to me tells me that they may have actually credited her, but they decided to split the baby because it appears to me that he understood the severity of the charge. And the name itself, predatory sexual act, tells you implicitly that the sentence is going to be much graver and much higher. So I think that was, in essence, them crediting the defense, splitting the baby, but ensuring that Harvey got convicted.
Bruce, your thoughts on this conviction?
I think the conviction is subject to a pretty strong appellate attack. The testimony here was that he had consensual relationship with both of these women over a long period of time. And I take the point that you can have consensual sex 10,000 times and there can be rape once. But the question is proof beyond a reasonable doubt. And what I heard from that juror is a brilliant jury selection process from the prosecution. He repeated just what they fed him for sure. It can be rape, the consent, no consent once is rape. If he had been indoctrinated, if you will, better jury selection process from the defense and had acquitted, you would have heard things like, well, maybe, we're just not sure. There has to be proof beyond a reasonable doubt. We have all these other instances where they were having sex consensually. How would the defendant know this one was not consensual? And we have all these what we call Malmo witnesses in New York who came in and testified about other conduct of the defendant. That's going to be the subject of the appeal.
So you see a potential error of law there. Let's move on to other cases tonight. The Connecticut Supreme Court has dismissed an appeal we've talked about before here on the Debrief in the case of wealthy murder defendant Fotis Doulos. Doulos committed suicide while his criminal case worked its way through the trial courts. A trial judge issued a gag order which Doulos appealed. The court issued no official opinion, the appeals court that is, on why it dismissed the appeal, but it's likely because the issue is moot. Doulos' attorneys unsuccessfully attempted to keep the case alive to set precedent for future defendants whose cases were tarnished, the defense argued, by publicity and where gag orders prevented defendants from fighting back. A change in Virginia state law has affected the appeal of the D.C. Beltway sniper, Lee Boyd Malveaux, now 35, shot and killed 10 people and injured 3 others back in 2002 with help from his surrogate father. The governor of Virginia signed legislation which allows defendants convicted as teenagers a chance at parole, a chance after 20 years. As such, Melvaux dropped an appeal to the U.S. Supreme Court, which held in 2017 that the use of life without parole sentences for juveniles should be reserved for only rare cases. Melvaux's convictions are in both Maryland and Virginia, however, and it's unlikely he will ever live outside bars. Plus, a chance at parole does not make parole likely. An Indiana police reserve officer has himself landed behind bars after arresting his 15-year-old son solely, authorities say, as a scare tactic. They say 37-year-old Timothy Hayes Jr. handcuffed his son and left his son unattended for half an hour in a local police station in Southport near Indianapolis. The reserve cop father is charged with criminal confinement and neglect of a dependent. Testimony is underway in a civil suit against the Department of Social Services and Child Protective Services in Washington State over the presumed killing of Susan Powell and the killings of her 2 children. Law&Crime legal analyst and attorney Ann Bremner is representing the victim's family and filled us in on where the trial stands.
Well, we're in week 4, and this is a case where Josh Powell, that was the suspect in killing his wife, and then, unbelievably, the state agency, CPS, who's supposed to be tasked with keeping kids safe, it's in their name, had home visitation with Josh Powell with these 2 boys, where the boys were also potentially witnesses to their mom's homicide. They were saying things like, "Mommy went with us on a camping trip, didn't come back. It was in a snowstorm in Utah." That was his explanation for how she disappeared when these kids were 2 and 4. Things like, "Mommy's in a mine," drawing a stick figure of their mom in the trunk of a car, coming back, etc. So there's a homicide where they are apparently witnesses to their mom's homicide, where the state decided to let visitation occur in his remote, rented, staged home in Seattle, or excuse me, in Puyallup, and they didn't tell the judge. And so it's just a remarkably tragic case where my clients lost their daughter, Susan Cox Powell, who's been missing for 10 years, and then their grandchildren were killed with a hatchet, and then their wounds were filled with gasoline by Josh Powell, and then he set them on fire.
A niece related to 2 missing Idaho children says she strenuously denies knowing the whereabouts of either Joshua Vallow or Tylee Ryan. Idaho authorities are making plans to bring mother Lori Vallow back to their state from Hawaii to face felony charges. A transport date of March 4th is set for her. Vallow is accused of deserting and failing to support her children. Authorities in Milwaukee, Wisconsin have named the 5 victims of a shooting at the factory which produces Miller beer. The victims ranged in age from 33 to 61 and worked as machinists, electricians, and powerhouse operators at the sprawling brewery and office facility. Police say 51-year-old Anthony N. Farrell, the gunman, killed his co-workers and then killed himself. Sources who refused to give their names told the Milwaukee Journal-Sentinel that Farrell complained of racial discrimination at work and that he had a long-standing disagreement with at least one of the victims. Police, however, have not confirmed a motive. A jury is seated and opening statements are set for next week in the murder trial of real estate heir Robert Durst. The state's theory of the case is that Durst killed his friend Susan Berman because Berman knew Durst had killed his wife, Kathy Durst. We are watching the California courtroom very closely here at Law&Crime. Cameras are allowed for parts of the proceeding, but we're working to bring you as much coverage as we can under the judge's restrictions. And still ahead tonight, we're going to head back to Wisconsin here on the Debrief for the trial of a man accused of shooting his son in the head after a night of drinking. The father says the shooting was an accident. The jury has to sort it all out. We'll bring you the testimony from today after this. A Wisconsin father is on trial over charges he shot and killed his own son after a night of heavy drinking. 44-year-old Kayle Fleischauer is being tried a second time for second-degree reckless homicide. 19-year-old Chase died from a gunshot wound to the head. Prosecutors blame the father, but the father says Chase accidentally shot himself. The jury in the first case started conducting its own experiments to test the state's evidence. That's not allowed, and that's why the case is being tried a second time. The lead investigator described conducting a walkthrough of the house when he found Chase Fleischauer dead on the floor.
He was laying on his back in the dining room area of that residence with blood all around him. I observed what I believe to be a gunshot wound to the left side of his forehead. There was a stool, and his legs were entangled in that stool.
Was there any firearm in his vicinity?
No. In the living room, I observed an unspent shell casing. There was blood a lot of blood. I also observed a table in that dining room area that was against the wall. I noticed that there was a BB gun on top of that refrigerator. It was between some egg cartons.
What, if any, firearm did you see during this initial walkthrough in the house?
There was a firearm on the counter, an island counter across from the refrigerator. It was laying on the island counter. The magazine clip had been taken out of it, and the action of that firearm was open, and I could tell that it had been cleared and secured, and the round that was in the chamber was sitting next to that firearm.
That investigator attempted to recreate the shooting at a firing range in order to determine how far away the pistol was from the victim.
We test fired this particular weapon. These are spent shell casings from that firing.
Where did you get those shell casings from that you used in September of 2018?
They were in a drawer next to where the holster was found. These are the targets that we fired at, did the test firing.
Detective, based on that examination in September of 2018, what conclusion was reached regarding the range of fire of the pistol from Chase Fleischauer in the early morning hours of April 14th of 2018?
Approximately 5 to 6 inches.
On cross, the defense wanted to know how much investigators looked into the defendant's daughter, Summer, who tearfully testified she called 911 to report the shooting when the defendant, the father, told her not to.
I swabbed for DNA and believed I could utilize those for GSR as well.
Okay, so when you did the swabbing, you separated the swabs afterwards and sent some to the DNA office and some to the GSR office?
No, I took the swabs, put them into evidence, then they were later split.
Did she also tell you that she was drunk at the time she heard the chair fall, or she heard the noise upstairs?
Yes.
Did she say her father told her that he had stashed a gun on top of the refrigerator?
Yes.
And did you say to her, well, he said he has guns ready in case somebody comes in? Do you remember her agreeing with that? And that he had that gun up there for house protection?
Yes.
She also told you that she was not aware of any fights between her father and her brother during the time growing up, correct?
Yes.
The state then rested, and the defense called as its first witness a firearms expert who just happens to be one of the defendant's personal friends. He did his own recreation of the shooting.
We started to build a fixture to better hold this firearm. Lance Fleischauer was initially involved in this, and then I took over.
And who's Lance Fleischauer?
Lance Fleischauer is Kayle's uncle. The table that is used there is approximately the height of the center island in the kitchen at Mr. Fleischauer's home. The wood flooring is similar in design, as well as the carpet that the handgun was originally found on.
Distance traveled 13 feet 6 inches.
Correct.
What condition was the pistol in after it traveled that distance?
The firearm malfunctioned and did not load or chamber another round.
Trying to explain how the gun got that far away. Well, on cross, the state asked that friend to read several questionable messages he sent to the defendant's daughter after she testified in the first trial.
I am not sleeping. I imagine I am not the only one. I just had to say a couple of things. I'm sorry for the loss of your brother. My son is the same age. Kayle and I talked about our kids often, sometimes to share the obvious frustration of teens, but what was most evident was the overwhelming love that we shared for them. I have no idea why I'm sending this. I am not a Facebooker. That is all that I have at this moment. The second thing I wanted to say is that I hope at some point you find comfort and healing. You are a beautiful young lady that has accomplished much and deserve even more. I don't want anything to hold you back. If you harbor these hard feelings and will against your dad, it will greatly impact your progression, happiness, and love for those that are closest to you. How do I know? I've experienced the damage of not forgiving my dad for ending his life early. It is a long story, but in the end, I have suffered, and so have my kids. If I could change one thing in my life, it would be to forgive the terrible thing that he did and allow that love and peace to affect me and this next generation. This sucks. Here's wishing you the best, Summer. I'll be praying to get through this week and hope for some recovery as soon as possible.
Okay, let's bring our guests in one final time. Brian Buckmeyer with me in the newsroom right now. Brian, how do you interpret that message?
I'm a defense attorney, so I'm going to interpret it as innocuous as possible. This is someone who is moved by their compassion to reach out to someone who they see as hurt, and hurt in a similar way that they were hurt, but it does not mean that he's admitting that Kayle Fleischauer, in fact, did anything wrong.
Brian Buckmeyer's take there from the newsroom tonight. Okay, let's turn in studio. Aida Leisenring, Bruce Barquette. Bruce, your interpretation, I mean, what's the purpose of bringing that in? Is it just simply to show bias here?
From the prosecutor's perspective, yes. It shows, I think, three things that are devastating for the witness. One, it's kind of creepy. Two, forgive me. Two, it shows a strong emotional attachment to the defendant, which could cloud an individual's judgment. And three, it seems like the daughter is blaming the father for her brother's death, and in a reckless homicide, that's a serious problem for the defense.
Well, I mean, she did indeed testify against her father. So, Aida, victim's DNA is on the barrel of the gun. Other DNA tests inconclusive. The victim had gunshot residue. The victim had the gunshot residue on his left hand. The father was extremely drunk, with some estimates putting his blood alcohol level between 3 and 5 times the legal limit to drive. Okay, he was at home. You can be that drunk, but does the state have this case beyond a reasonable doubt here?
I don't think they do, and I hate to victim blame, but here all the forensics point towards the victim.
In other words, he may have had the gun.
Exactly. And the only testimony that's indicative of the father doing it is ultimately his level of intoxication and that he was in the room.
And behavior. Good insight from our guests tonight here on The Debrief. I'll see you back here Monday at 5 o'clock, everybody.